we're back again. Hope you had a nice break. And I think we're going to have another excellent panel. Again, I want to thank Kathleen and the entire panel that came before that doing the hot tubbing, because that's something unusual that you don't get to see, so I thought that came out great. This next panel is going to be very, very interesting. It's basically debating, and the question presented is the doctrine of unclean hands should be a complete defense to an investor's claim. And I'll let Sandra go ahead and introduce, the incredible panel, but let me just mention Sandra, my friend Sandra, who heads up the dispute resolution practice at FEDREG. I was going to say in Uruguay, but I'm now reading that it's in Bolivia, Paraguay, Uruguay. And, a well-known arbitration counsel and arbitrator. So anyway, Sandra, thank you so much and take it away.
Thank you, Luis. Good morning, everyone. It's a pleasure to be here. And I want to thank, of course, the organizers for inviting me and our debaters.
And
so, a word of caution here, that is that, of course, we have roles assigned to each and every one of us. So what you're going to hear today are not necessarily our personal views on the subject matter of our panel. And even we are not necessarily who we are saying we are, maybe. And so this is just the roles we were assigned to have for this panel. I have 4 very well-known practitioners for this debate, and I am going to introduce, in favor of the proposition that the doctrine of unclean hands should be a complete defense to an investor's claims, we have the Attorney General of Ecuador, Juan Carlos Larrea. And we also have Brian Baca, associate at Hughes, Hubbard & Reed. Against the proposition, we have Daniel Pose, a partner at Pose Herrera Ruiz in Colombia, and Harry Burnett, a partner with King & Spalding. So we are going to start the debate and kind of a setting of what we are going to do here. So we are going to assume that we are in a session in which I am going to hear debaters on this topic. So good morning, everyone. Good morning to counsel to one of the parties in this case, and good morning to the counsel to the other side. I am grateful that you are here today to actually illustrate me and, of course, the audience, to illustrate me on something that is kind of new to me in this case, because as you know, this is just my only second case as an investment case, as an arbitrator, and I had never faced this doctrine before. So that's why I convened this session, and I'm grateful that you are here today on a Sunday in Miami. Although, of course, I know that you actually were saved from going to the beach on a sunny Sunday in Miami. It's kind of too crowded, too sandy. So I'm sure that you are grateful to be here. So let me start by saying that, as I mentioned, I am not familiar with this doctrine, but I tried to do a crash course so that this session today was more useful for me, of course, and for you to explain it to me. And correct me if I'm wrong in your presentations, but I understand that the doctrine comes from the common law, and it basically means one who comes into equity must come with clean hands. And if I am correct, this evolved from, or as a way, so that the court system could actually not necessarily apply the law as it is, but have some more leeway to consider fairer solutions that do not come from common law or statutes in its origin at this common law setting. So, and my understanding is that what we are discussing here is that in a context in which claimant investor is said to have been involved in improper conduct, therefore the state is actually claiming for a complete defense, so that I should do whatever you're going to explain that you've been asking me to do. And on the other side, you are opposing vigorously, and you actually want me to go to the merits of the case before, and not take any decision on this matter as a preliminary basis. So, as you know, we have decided that we're going to allow 15 minutes to each of your initial presentations, and I am going to let you present and not ask questions unless I want to, okay? So if you could start, I'm not sure who's going to take the lead first. Is you, Mr. Baca? Yes, please go ahead.
Yes, Madam Arbitrator. Can everyone hear me? Yes. Well, first, good morning, Madam Arbitrator. Good morning, colleagues. My name is Brian Vaca, and I, along with my colleague Juan Carlos Larrea, as Madam Arbitrator said, will be defending the proposition. Before presenting our arguments, let's begin with considering the broader context. As many people here are aware, the ISDS system in Latin America is facing a crisis of legitimacy. A few years ago, as everyone knows, several countries renounced Dixit. Subsequently, new agreements such as the USMCA have placed a limited scope on disputes. But why are some parties losing faith in the system? There are many reasons, but one recurring concern is the perception of unfairness. Fairness is fundamental to trust in the system. Without trust, this process risks becoming irrelevant, particularly in a region where its legitimacy is already under heavy scrutiny. This issue of fairness, Madam Arbitrator, is central to today's discussion. Is it fair to allow the unclean hands doctrine as a complete defense, or is it fair to deny it? We believe it is fair to allow it, and this position is rooted, frankly, Madam Arbitrator, both in common sense and in foundational principles of equity that underpin this entire system. Now, before we present why the unclean hand doctrine should be a complete defense for a state from an investor's claim, we must first get to the core of what it means. The idea behind the concept, as Madam Arbitrator is aware, has seen varying nomenclature, formulations, and holds close ties to several foundational principles such as good faith, the legality requirement, and Latin maxims reflecting equitable principles. Its source of obligation can often be traced to public policy, particularly the prohibition against rewarding or legitimizing unlawful conduct. The core idea of the unclean hand doctrine is simple. A party cannot seek relief or assert a claim if it has acted unlawfully or in bad faith in connection with the matter at hand. It's that simple. In the context of investment arbitration, this means that an investor who has engaged in illegal or unethical conduct, such as fraud, corruption, or serious violations of local laws, may be, and in our view must be, barred from pursuing claims against the host state. The unclean hands doctrine serves several key purposes, and I'll just name two for now. The first is it reinforces the idea that the treaty protections in international arbitration are reserved for investors who respect the rule of law. And second, it acts as a safeguard against claims that might otherwise legitimize or reward misconduct. It protects the integrity of the entire system, Madam Arbitrator. However, we are aware that the application of the doctrine is not without controversy. Critics, as we're sure opposing counsel will argue, that allowing states to raise unclean hands as a defense could lead to abuse, especially when the states themselves are complicit in the wrongdoing. We believe that position is misguided, but we will reserve our right on rebuttal to address the flaws in the arguments should counsel raise those arguments. But now we will proceed to explain why the unclean hands doctrine should be a complete defense for a state from an investor's claims. I'll address 5 quick points, and then my colleague Juan Carlos Larrea will address 5 additional points and conclude our opening. The first point is the doctrine of unclean hands stems from the equitable principle that one who seeks equity must do equity. Investors who have acted illegally should not be entitled to remedies in international arbitration, Madam Arbitrator. Allowing these claims undermines the legitimacy of the system. The second is that recognizing the doctrine of unclean hands as a complete defense to an investor's claim encourages the preservation of international public policy. The preservation of international public policy is central to investment arbitration. Accepting claims from investors who engage in bribery, corruption, or other illicit acts would violate these core principles, Madam Arbitrator. And many tribunals have emphasized that corruption and fraud cannot serve as a basis for claims. Just to name one example, the Tribunal in World Duty Free v. Kenya, which many people are aware of the decision, stated, and I quote, "This tribunal is convinced that bribery is contrary to the international public policy of most, if not all states, or to use another formula, to transnational public policy. Thus, claims based on contracts of corruption or contracts obtained by corruption cannot be upheld by this tribunal." And Madam Arbitrator, this view has been shared by many other arbitral tribunals. In other words, what is the result for these violations? Not a decision in favor of the investor who committed the violation of public policy. The third point is that the tribunal's duty to consider the principle of good faith when determining jurisdiction. That also supports the unclean hands doctrine as a complete defense. And here I'll cite to the tribunal in Incesa v. El Salvador, where the tribunal said that it must consider the principle of good faith when determining jurisdiction. And notably, and more specifically, that tribunal held, and I quote, "By falsifying the facts, Incesa violated the principle of good faith from the time it made the investment, and therefore it did not make it in accordance with Salvadorian law." Faced with this situation, this tribunal said that it can only declare its incompetence to hear Incesa's complaint, since its investment cannot benefit from the protection of the BIT. This closely tied principle, Madam Arbitrator, also supports unclean hands as an absolute defense. Fourth, another point that supports this defense is the tribunal's duty to consider the principle of, and apologies in advance if I mispronounce this Latin maximum, nemo auditur propriam turpidudem allegans. This principle has been expressed in Spanish as nadie puede beneficiarse de su propia torpeza o dolo, or in English as no one shall be heard who invokes his own guilt. It's been articulated in several different ways. In this regard, applying that principle, the same tribunal in Incesa held as follows, and I quote, "We can affirm that the foreign investor cannot seek to benefit from an investment effectuated by means of one or several illegal acts. No one can benefit from his own fraud." This closely tied principle, Madam Arbitrator, also supports unclean hands as an absolute defense. And fifth and finally, on my points, while the tribunal and some jurists have opined that the unclean hand doctrine does not exist as a general principle of law that would bar a claim of an investor, the view that should be adopted is the one that has been adopted in more recent decisions, such as in LATAM Enterprises v. Ukraine, where the tribunal held, and I quote, "The doctrine of clean hands, just like the concept of good faith, is now a principle of international law." As such, the consequences numerous tribunals and jurists have recognized apply to violations of these foundational principles that underpin the doctrine of unclean hands lead to one conclusion, Madam Arbitrator: the recognition that the doctrine of unclean hands should serve as a complete defense to an investor's claim against a state. I will now hand the microphone over to my colleague, Juan Carlos Larrea, who will touch upon 5 additional reasons and conclude.
I'm sorry, just before you start, Mr. Larrea, before I forget that, I want to ask you this question to you, Mr. Bata. You started by saying that the legitimacy of investment arbitration or ISDS is into question these days, and then actually later on in your presentation, you talked about the system repeatedly. So I want to understand if it's your position that as an arbitrator, I have a duty not only to resolve this case, but also to preserving the system or its legitimacy? Is that what you're saying?
Thank you, Madam Arbitrator. I would say the arbitrator has a duty to resolve this case, but always the principles of equity can always underpin any decision that the tribunal makes. The tribunal should consider concepts of equity. It's not mandated or obligated to necessarily rule on issues of equity, but it is something that should guide its decisions as it evaluates a matter.
Okay, thank you. And then you will have your turn if you want to comment on his answer to my question on your time, okay?
Me too.
Mr. Larrea, please.
Thank you, Madam Arbitrator, and to the organizers and to you. Thank you for the opportunity to bring you my view, not as an expert on investment arbitrations, as my colleagues are, but from a perspective of a public official. I will continue the arguments that Brian started to outline. Argument number 6, doctrine of legality in international investment law. The legality requirement in many treaties, explicitly or implicitly, implies that unlawful investments should not enjoy treaty protections. The unclean hands doctrine aligns with this principle by barring claims that originate from illegality. Investment treaties often include provisions requiring investors to act in accordance with host state laws. The doctrine of unclean hands enforces these requirements by barring claims for investors who violate the law. Recently, the tribunal in Worley versus Ecuador addressed a question that is in line with this issue. It framed the issue as follows, and I quote, "In the tribunal's view, the crucial question is not whether it should read a legality requirement into the treaty, but rather whether a tribunal should assume that a state would have given its consent to arbitration to protect investments that breached its own law. This question must clearly be answered in the negative. Relying on cases such as Finnish Action versus Czech Republic, Incesa versus El Salvador, and Plama versus Bulgaria, the tribunal concluded that, and I quote again, "The absence of an express legality clause in the treaty does not preclude an inquiry into whether the claimant's alleged investment complied with the law. Any such illegality may impact the adjudication of this dispute in several ways. In particular, existing illegalities may deprive the claimant's alleged investment from the substantive protections of the treaty, bar the jurisdiction of the tribunal, or the admissibility of the claimant's claims." In Worley, ultimately, the tribunal decided that the illegalities committed by the claimant, quote, "deprived the tribunal of jurisdiction over the entirety of the claimant's claims." And I quote again, "The tribunal is, therefore, faced with a widespread pattern of illegality and bad faith affecting the centerpieces of the claimant's investment from their origination and flowing into the claimant's subsequent investments in Ecuador. In the tribunal's view, such circumstance is sufficiently serious so as to deprive it of jurisdiction. This conclusion is dispositive of the entirety of the claimant's claims. Treaties are not designed to protect unlawful investments. Enforcing the doctrine ensures that protections are granted only to those who uphold their obligations under the treaty framework. We emphatically reject the contention that international investment treaties provide protection to investments made in bad faith in the absence of an express legality clause, and can cite to numerous tribunals supporting the proposition that investments are not protected if they violate the host state's domestic law and the principles of good faith. Argument number 7. Affirming that the doctrine of unclean hands is a complete defense to an investor's claim would be also consistent with the object and purpose of investment treaties. As provided by Article 31 of the Vienna Convention, a treaty must be interpreted in good faith and in accordance with its object and purpose. The object and purpose of most, if not all, investment treaties does not include the promotion and protection of illegal investments. Rather, as stated in several treaties' introductory notes, the fundamental aim of the treaty is to strengthen the rule of law. Argument number 8. Investors should be incentivized to conduct due diligence and act responsibly in host states. Allowing claims from investors with unclean hands diminishes the deterrent effect of legal standards against corruption, fraud, or exploitation. By applying the doctrine as a complete defense, the system promotes sustainable and ethical foreign direct investment. Argument number 9. The clean hands doctrine is recognized in many domestic laws and also in international legal principles. Its application in investment arbitrations aligns with established jurisprudence in both spheres. Argument number 10, the last one. Efficiency in the arbitral process. Adjudicating claims from investors with unclean hands wastes time and resources on cases that ultimately undermine the credibility of the entire system. A clear application of the doctrine as a complete defense streamlines the process and avoids prolonged disputes over merits in cases tainted by misconduct. As a conclusion, Madam Arbitrator, the application of the doctrine of unclean hands as a complete defense is essential to preserving the fairness, integrity, and credibility of the international investment arbitration system. It promotes ethical behavior, respects international public policy, and ensures a balanced approach to investor-state disputes. By applying this doctrine, tribunals affirm their commitment to justice and the rule of law. Thank you, Madam Arbitrator.
Thank you, Mr. Larrayan. Before going to the other side, let me just ask you this follow-up question. You mentioned that when you cited Worley, you mentioned this question that the tribunal asked about whether the state would have entered into a treaty allowing the investor to actually come to an arbitration with dirty hands or unclean hands. And I want to ask you if, in your view and from your position, it makes a difference whether or not the treaty allows for or requires legality of the investment, or in more modern cases or the new generation treaties, you have unclean hands specifically mentioned. How does that guide me as an arbitrator to resolve this issue?
Thank you, Madam Arbitrator. This question has already been issued by several authors and by numerous tribunals. And the conclusions issued in recent awards is, for my opinion only, that it is not really material, it's not really relevant if there is or there are not express illegality clauses in the treaty. Since the unclean hands doctrine and the related principles of good faith are also linked with the compliance of general principles of international law. So, for example, in several awards, the recent of worldly parts of the tribunal expressly stated that it is not relevant if there is no legality clause in the treaty.
Thank you. Mr. Burnett and Mr. Bose, it is now your turn.
Thank you.
Remember, you have 15 minutes and discounting whatever time I take for questions, okay?
Thank you, Madam President. Dr. Larrea, Dr. Vaca. The clean hands cannot be a complete defense to absolve a state of its blatant treaty violations like expropriation, to permit a state not only to avoid responsibility for violations of international law, but also to enrich itself in the process. We did not hear much from our colleagues about the fact that the clean hands doctrine is not a general principle of law. In 2023, a case certain Iranian assets, Iran claimed the U.S. violated the Treaty of Amity, Economic Relations and Consular Rights. The U.S. asserted a defense based on clean hands. The court noted that the argument based on clean hands doctrine has only rarely been upheld by bodies before which it has been raised. The court noted that it has never upheld that doctrine as part of customary international law or constitute general principle of law. Many articles written by scholars also echo this. And I'm not going to name the authors, but here are some of the propositions that have been set forth in this literature. The application of the clean hands doctrine in international law is still controversial. International tribunals have so far been reluctant to recognize its existence. The clean hand doctrine inconsistency has indeed been underlined in recent PCA arbitration between Guyana and Suriname. The clean hands doctrine has been rarely applied. The clean hands doctrine is still considered as a controversial principle. The ICJ has not explicitly upheld the unclean hands doctrine by any majority opinion. For example, also in Nico Resources versus Bangladesh, the tribunal stated, the question whether the principle of clean hands forms part of international law remains controversial and its precise content is ill-defined. The tribunal in 2022 in Mercuria Energy Group versus Poland said the issue of unclean hands is far from being settled in international investment law. The Yukos versus Russia tribunal from 2014, which I think has probably given one more extensive analysis of this, said the tribunal was not persuaded that there exists a general principle of law recognized by civilized nations within the meaning of Article 38(1)(c) of the ICJ statute that would bar an investor from making a claim before an arbitral tribunal under an investment treaty because it has so-called unclean hands. The tribunal in South American Silver versus Bolivia, the tribunal came to the same conclusion after extensive briefing by the parties and covered it in over 33 pages of the award. The tribunal stated that to examine the merits of Bolivia's admissibility defense, it would have to be convinced that the clean hands doctrine is a general principle of international law or that it forms part of international public policy. Based on the arguments and evidence, the tribunal was not convinced. The tribunal noted that Bolivia claimed that the clean hands doctrine is part of international public policy and embodies the good faith principle. But the tribunal found that the good faith is indeed, of course, a principle that is valued by international law and indeed all law, but that good faith is not a principle that regulates the jurisdiction of an investment arbitration tribunal or admissibility of claimants' claims. The good faith principle says nothing about how, by what rules, and under what conditions a lack of good faith could operate as a jurisdictional rule. The tribunal concluded that the tribunal finds that Bolivia has not shown that the clean hands doctrine is part of international public policy or constitutes a principle of international law applicable to the present case, and that defeats the jurisdiction of the tribunal or affects the admissibility of the claims filed by the claimant. Secondly, and I think that this is important for this debate, that our adversaries seem to be conflating the legality doctrine with the clean hands doctrine, as often is the case. The legality doctrine relies on terms of the investment treaty at issue, such that in order to fall within the scope of the BIT, an investment needed to be lawful under or in accordance with the host state laws and regulations at the time the investments were made. One of my colleague, I think Dr. Larrea, mentioned the LITAP case, maybe it was Dr. Vaca, which that the analysis in that case is inferior to the UCOS analysis and the ICJ's recent judgment. It's more of a legality clause implicit because of the ECT, Energy Charter Treaty argument, than a clean hands analysis. It was a way to bring in legality clause arguments for a treaty that didn't explicitly allow it. Unclean hands should be considered on the merits of the case. The clean hands doctrine should not be used to achieve an unfair and inequitable outcome. If clean hands doctrine were to be applied to dismiss a case in its entirety, it would permit the respondent state to capture the entirety of the benefit of the claimant's investment without any consequences. The law abhors such unfairness. Professor Crematis' dissent in Fraport versus the Philippines case should be remembered. He says, if the legality of the claimant's conduct is a jurisdictional issue and the legality of the respondent's conduct is a merits issue, then respondent host state has placed in a powerful position. In a biblical phrase, the tribunal must first determine the speck in the eye of the investor and defer and maybe never address a beam in the eye of the host state. Such an approach does not respect fundamental principles of procedure.
That's dope.
Despite the fact the question of whether clean hands doctrine forms part of international law is still not only debatable, but it's would take the position that it does not. The Nico versus Bangladesh Tribunal discussed the doctrine at length, stressing the need for reciprocity between obligations of the investor and the host state. The Nico Tribunal found that in a situation where corruption occurred after the subject of the investment, which was a JVA, had been concluded, there is no relation of reciprocity between the relief which the claimant now seeks in this arbitration and the acts in the past which respondents characterize as unclean hands. Thus, in order to sustain a defense on unclean hands to the extent the doctrine exists at all, reciprocity is required. There's a 2024 article of the ICSID Review by Yuming Yan, which provides as follows. Reciprocity is the key attribute of the clean hands doctrine, if it even exists as international law, which requires that the two alleged illegalities, one illegality is alleged by the claimant and the other is alleged by the respondent, who's also the party raising the clean hands doctrine, are precisely similar action, similar in fact, and similar in law. In allegations of corruption, we must ascertain whether the alleged treaty breaches by the host state, i.e. Illegal expropriation, is precisely similar to the alleged investor wrongdoing of the corrupt act. As these two types of misconduct are not reciprocal, the clean hands doctrine cannot be invoked to support allegations of corruption. The note further, she further says that the host state's clean hands submission should be dismissed on account of its own unclean hands, given that giving a bribe and receiving a bribe are pair of reciprocal actions in nature.
How are we doing?
Let's see. The other important concept is proportionality. While it's true that investors can sometimes act so illicitly as not to be entitled to arbitral redress, host states can and historically have engaged in arbitrary and egregious conduct as well. The UCOS claimants argued that the unclean hands doctrine would not confer upon states the right to violate investors' rights, and argued the principles of proportionality required the tribunal to consider investors' illegality vis-a-vis the host state's original breach. I think I'll turn things over to my colleague, but this is also embodied in the Kim versus Uzbekistan case, that tribunal should deny protection of a bid only when its application is triggered by noncompliance with a law that results in a compromise of a correspondingly important interest of the state.
Yes.
Thank you.
May I just, before you proceed, Mr. Bose, I want to ask a question from Mr. Burnett. You did say, and you questioned the doctrine in itself as being controversial, and you said even not necessarily debatable, right? So I want to understand your position with respect to the following issue. My understanding is that the unclean hands doctrine, in its origin, let's say, in the common law system, it has been said that it did not necessarily protect the defendant in the cases, but the system, the adjudication system in itself, so that the protection goes towards the system and not necessarily the defendant in each particular case. And I want to understand if you agree or not with that particular point with respect to investment arbitration.
Of course I do. I think that the principles that I've laid out here accomplish that by requiring proportionality, reciprocity, and the appropriate application of the unclean hands doctrine, which really has not been defined in any material way. But I do agree that one of its purposes is to maintain the integrity of the system itself. And I guess in common law it was the court.
And should I then not consider that I need to address that matter if, as it is alleged in this case, should I not consider that matter at the very beginning of the case as a jurisdiction or admissibility matter? Because that otherwise that would allow the investor my ruling on the merits. So I want to understand what your position is specifically on that. Why should I go into the merits of the case if at some point what the doctrine is saying is that the investor should not be allowed the protection of the arbitration in itself? Why is this not a question of jurisdiction?
Well, I think in order to adequately address that question, you need to hear both sides and the conduct of both parties, which the states have always tried to eliminate, such that the burden is only on the investor. And so I don't think that this should be some sort of the integrity of the system issue should be some sort of trump card or gateway issue for your decision, such that you would dismiss it on jurisdiction or admissibility grounds.
Thank you. And then you will have, of course, on rebuttal, the opportunity to address this matter as well. Mr. Pose, you may proceed now. Thank you.
Oops.
Okay.
Hello.
Timur.
Yes. In addition to what Harry has said, we would like to highlight also some considerations. First,
as our respected colleagues said, it's a principle of really of equity common law. Is then by saying that they accept that it's not an international law principle, but it's a practice that has been trying to extrapolate from an equity law principle into international law. And by doing so, as Harry also expressed it has been created into a confusion with some other rules. It's we can see in the decisions that were quoted and some others, as well as in the presentation, that it's usually mentioned together with the legality principle. And we believe that those are two different principles. And the legality principle has to go into the actual wording of the treaty that is applied. There is also this discussion about whether this legality principle, if it is not expressed in the treaty, could be considered to be implicitly included. But even in those cases, the wording of the treaties, like the Energy Charter Treaty, refers to the legality at the origin of the investment. So the moment on which the corruption, if we talk about the particular case of corruption and not an illegal conduct occurs, is particularly relevant. Because if the corruption occurs not in the origin of the investment, but in the performance of the contract, then the actual wording of the treaties, like the Energy Charter, the ECT, will not apply to the case. We know that some awards have mentioned that it should be considered to apply also extensively to a performance, but that in our opinion, that is an improper extension of a sanction regulated by the treaty. Sanctions cannot be applied by analogy or by an extension or wide application. So the moment in which the illegal act occurs is particularly relevant. But also, as Harry was mentioning, is not only the moment, but also if that corruption was unilaterally or bilateral. Because if applying into a case through the legality principle and not the unclean hands, the fact that the state also participated should be considered by the tribunal, and that can only be done in the analysis of the merits. It's not a jurisdictional matter. Actually, in the JUCO case, the award concluded that it was a matter of how do you say in English? Is concurrency.
Concurrent conduct.
Yeah, concurrent conduct, and reduced the sanction in 25%. So based on those considerations, we clearly consider, Madam Arbitrator, that it is not a matter of jurisdiction, but it's a matter of the merits. We will also like to highlight that quoting the good faith principle is very vague, is very difficult to understand. The good faith is one of the more difficult concepts to make a concrete concept. So it's open, abstract, undefined. Actually, some of the cases that were quoted mentioned that is a good faith understood as a willful misconduct. So it requires for the unclean hands, if it were going to be applied, even through the legality principle, requires to analyze if there was a willful conduct to incur in the illegality, and that can only be done through the thorough analysis of the evidence that has to be collected, and therefore that's an analysis that has to be done in the merits and not a jurisdictional matter.
Thank you, Mr. Pose. Let me ask you a follow-up question on two matters that you mentioned, and let me start by the last point you made. You said that the tribunal needs to take into account whether the investor's conduct was willful, right? Am I to assume that in a case of corruption, which is obviously you cannot get into corruption without willful misconduct? I have yet to see a case in which corruption is just negligence, but one does not happen to pay something to a public official just because. So in those cases, should there be a distinction? If corruption is involved, then it is admissible for the tribunal to actually treat that as a jurisdictional matter or an admissibility matter.
You have, Madam Arbitrator, to analyze not only that element, which is the willful wrongdoing, but also the connection, and therefore, because these contracts and projects are very complex and are long-term execution. So, if we are not talking about a corruption to get the contract, but a situation that might be considered a corruption, but it's in the performance of the contract, done only for example, to accelerate a permit, and it's done not by a decision of the company, but by a mistake of a lower level officer of the company, then that's something that has to be considered by the tribunal to, as I was saying, analyze the concurrent causes. So it's a matter of the element of the willful wrongdoing, but also the connection, the proportionality of that conduct with the claim that is being made. Because even in the unclean hands doctrine on equity law, it says that it requires first connectivity, and second connectivity is with the claim. So it's not any fact of corruption that may have occurred in a 10, 20, 30 years long term contract. So
okay, maybe for rebuttal, I would like for you to consider this issue about whether you are actually claiming that there were unclean hands at the very beginning of the investment, as opposed to during the performance or the operation of the investment. And specifically, I want to ask if, because we all know that in these long-term investments, as you mentioned, Mr. Pose, there are issues, intermediate issues, like you said, getting a permit, different kinds of regulations that you have to comply with, different type of licenses, etc., etc. But then also there are multiple investments potentially in a long-term investment, and you may get. You may make the investment at the very beginning, but then in a 30-year case, for example, you may have had subsequent investments. And what happens in that case? What the tribunal should do? Is that something that changes a little bit what you were saying with respect to do not take a look at what happens after the original investment, even if maybe subsequent investments are more substantial? Now you have 10 minutes for rebuttal. So starting with you, Mr. Baca, and Mr. Larrea. Okay.
Thank you, Madam Arbitrator. So I will address two separate points first. One is to points that our colleague, Mr. Burnett made, and is that he mentioned that the unclean hand doctrine has never been found to be a general principle of law. And he further said it's not customary international law. So just for clarity, Madam Arbitrator, we are not arguing, or it's not our position that it is that the principle of unclean hands is a principle of customary international law. If that was the case, of course, the debate would be much easier. We are arguing, however, and we did cite to matters, and this matter was not addressed by opposing counsel, that there are tribunals and there are various jurists that have recognized the unclean hand principle in investment arbitration, that it has become a general principle of international law. And I believe Counselor Pose at some point alluded to the fact that we recognize that it started as a common law principle, and that is correct. We do agree that it started as a common law principle, but then has evolutionized into a general principle of international law and cited to LITA v. Ukraine. Despite the fact that that case had a specific treaty, the tribunal did make a statement and a ruling unreserved that it has become a general principle of international law. Second, a second point I want to address, it relates to separating the state from the bad actors, because we do believe it's an important point. There were points made about proportionality. There were points made about that this would protect the state. And we would argue that to that point, and that is, we believe, the basis for the flawed reasoning behind the investor's side in viewing this issue, that there are four main reasons that this tribunal should take into consideration as to why applying the unclean hands principle does not result in absolving the state and is not a measure aimed at protecting the state. And there are four main reasons. One is unclean hands protects the system, not the state, as we have mentioned. Second is the focus should be on the investor's conduct, and I'll expand on all of these in turn. The third is the investor bears the risk of its actions. Oh, apologies. One step back, apologies. The first is we must distinguish between the state and rogue actors. The second is there is already accountability for bad actors, both on the state side and the investor side in domestic legal systems. Third is the state still faces consequences, even if we apply the unclean hands principle. And the fourth is the argument for deterrence misunderstands the behavior of corrupt officials. So starting with the first point on distinguishing between states and rogue actors, in cases where investors alleges that the state officials participated in illegal acts, it's critical to differentiate between the state, the sovereign entity, and the actions of a few bad actors within its government. Holding the state, and by extension its people, accountable for the misconduct of rogue officials undermines this distinction, protecting the legitimate interests of the state or the interest of these corrupted individuals. The second point on accountability for bad actors belonging to domestic legal systems, state officials engaging in corruption or other illegal acts, they face consequences under domestic legal systems, whether through civil or criminal proceedings. Those systems are better equipped to penalize people for those specific actions. The International Tribunal's role is not to sanction these individuals or the state. It's to assess jurisdiction, admissibility, and merits of the investor's claim, be it under a treaty or a contract. Applying the unclean hand doctrine respects this division of responsibilities. And another point, the state still faces consequences. State face consequences for their actions through the reputational harm as a whole. And then the fourth argument, the argument for deterrence misunderstands the behavior of corrupt individuals. The claim that rejecting the state's unclean hands defense would deter future misconduct, that's flawed because it presumes that corrupt individuals care about the state's ability to win an arbitration. In reality, such bad actors are often motivated by personal gain, not by the state's long-term interests. By not allowing the unclean hands as a defense, that does nothing to change the bad actors of the state. The only way that it can deter this poor behavior is is by protecting the system, and as a result, by being a complete bar to investors' claims. Thank you.
Thank you. You may proceed.
Yes, thank you, Madam Arbitrator. Yeah, I just want to add two points additionally to what Brian said. First of all, is one thing related to the temporal restrictions that has been addressed, I think, by Mr. Burnett. And that is precisely why we don't see as equals the illegality clause and the principle or doctrine of unclean hands, because the unclean hands doctrine has a broader scope. And the illegalities as a general matter may be addressed as part of the merits of a claim. Yes, that's right. But particularly serious illegalities concerning violations of international public policy may have the effect of barring the admissibility of claims. And this is stated in various awards. For example, in the famous Mélida award, the tribunal stated, the rationale for the temporary restriction on the jurisdictional legality defense, which is not to grant treaty protection to an investment made illegally, does not apply to an admissibility defense under the doctrines of international public policy and unclean hands. The reason why serious violations, such as a breach of international public policy, may bar the admissibility of claims is that international adjudicatory bodies have a duty not to entertain claims tainted by violations of certain universally accepted norms pursuant to general principles of good faith and the famous nemo auditur propriam turpitudinem allegens. And the second point I want to comment is already briefed by Brian brilliantly, that we cannot look as equals also the state, the conduct, the behavior of states are the misconducts or wrongdoings of some public officials, some rogue actors. A state, any state, represents the whole society. And we cannot reasonably think that a whole society, an entire country, is entering into some misconduct. So, for example, when a rogue actor, when a public official commits acts of corruption, this is a very serious breach of the public trust. And the main victim is precisely the society, represented by the state. Please think on one case, and let me talk about just 2 minutes, Madam Arbitrator, a case related to Ecuador, precisely. Yeah. Do you know that one of the biggest projects, infrastructure projects in Ecuador was what was called the Pacific Refinery? It was a big, very big oil refinery project. Well, Ecuador spent more than $1.5 billion on that project. And what we have? Nothing. $1.5 billion was spent on clearing of the land and ground leveling. That's all we have. How can one person reasonably think that the state who represent the society is not the main victim of the corruption? Thank you, Madam President.
Thank you. And before going to rebuttal from the other side, I want to ask you a couple of questions. number one for Mr. Baca. And actually, either of you can take this one because it's intertwined, the issue. I think both of you addressed this. Now, what you were saying, if I understood you correctly, is that there's a difference between, let's say it's corruption, what we are talking about. There is a difference between the state's officials that actually engage in corruption, and because the state's presumably, or the public interest is the one that's damaged the worst in those situations. How is that different from a case in which you have officers from a certain company which made the investment in the country? Why is it different in that situation? And let's assume for a minute that this company is a public company, and therefore, why is it different that shareholders of that company that might be teachers' pension funds or, those kinds of actors in the market? Why is it different? Why should we not allow some protection to those people as well, who are not necessarily engaged in, of course, because the company was not the one, but let's call them bad apples?
I'm happy to address the question, Madam Arbitrator. I think there's 2 points there I would like to make. I think number one, we have to be practical about it. There's a huge difference in most cases, maybe unless we're dealing with a much smaller country and a much larger company, where the decisions of the company reflect the behavior of the company at large, whereas the decisions of a state that is represented by a few actors that change constantly, change every 4 years or every 8 years, it might not necessarily reflect the behavior of the state overall. And second, I think an important point to address here is who is coming forward and trying to benefit from whether it be the treaty or the contract. It's the investor. If it was the other way around, I mean, we all know generally only investors can bring claims. That's a whole other debate, but only investors can bring claims under treaties. But if it was the other way around and a state wants to bring the claim under the treaty, then they will be subject to the same scrutiny as well. You are coming forward trying to benefit from a treaty, then you must come with unclean hands. So I think it's important to make that distinction. I think my mic is off, right? Can you hear me? Yeah, there we go. So I think it's important to make that distinction. You are the party seeking to reap the benefits of this treaty that has certain obligations, well, you must come forward with unclean hands. So that distinction is important. So it's those two reasons. One, we're talking about two completely different just infrastructures where the acts of the CEO is different from the acts. We can get into debates about whether it's the president. That is, I think, a whole other debate that we can have about standard and burden. But that is one point. And the other, as I mentioned, is who is coming forward and trying to reap the benefits. Thank you.
And thank you. Just one question, and this one is goes particularly to Mr. Larrea, because I think you started your presentation before saying that you were talking as a public officer, right? A public official. That's what you said. So, and you mentioned, and your colleague as well, how cases of corruption or when the investor comes forward with unclean hands, those issues really particularly damage the state and the public interest. And you would agree with me that corruption cases, of course, are against the state in itself and the public interest. That's obviously a given. So in those cases, are you not interested as a public official for the affording the investor the protections of the tribunal's jurisdiction in judging those cases? Would that not be a deterrent to conduct for officials to engage in corruption? Would you not want that to act as a deterrent?
Thank you, Madam Arbitrator. Yes, it's really interesting, your question. I have to say two points regarding your question. The first is, as Brian explained it minutes ago, the unclean hands doctrine does not exonerate the state for any non-compliance of its obligations. Does not exonerate any public official involved in corruption to the consequences of his or her actions. No, that's not the purpose nor the scope of the unclean hands doctrine. And the second point is really there is another form to view this issue. Is really the unclean hands doctrine is a deterrent for investor misconduct. Rejecting an investor's claim under the unclean hands doctrine serves as an additional and effective deterrent against investor wrongdoing, misconduct, corruption. Investors who justify unethical behavior by claiming I was obliged by the state, what is false. This is how business is done in that countries, are more likely to reconsider that attitude if they face the loss of their entire investment as a consequence. The possibility of criminal or civil liability already exists to deter such conduct, but adding the loss of investment protection creates, and that's my position, a stronger incentive for investors to avoid engaging in illegal acts, reinforcing, therefore, ethical business practices. Madam Arbitrator.
Thank you. It actually was my point that it takes two to tango. So that was how it acts as a deterrent for one participant, but not necessarily the other. So thank you for your comment and your 10 minutes for rebuttal.
Hello. Thanks, Madam Arbitrator. I have several points to contradict my respect colleagues on the points. First, I think that they are really recognizing that this is not a matter of jurisdiction, but a matter of the merits, and we thanks them for the arguments that contribute to our position. It's difficult to say that a tribunal has no jurisdiction. It must be a clear, undebated circumstance that concludes in no jurisdiction. And you can see they, with all my respect, but they use the words international law principles, public law, legality, host state local law. So it's not clear what is the rule, what is the standard, what is the consequence, what is the moment in which it applies, what is the relevance of the participation of the state. It's not clear. It's not the unclean hands, but the unclear doctrine, really. Second, they mention that it is also recognized by domestic law. With all my respect, in Colombia, and excuses to the audience for quoting my country, the state law, the state contracts law says that if a contract is annulled due to illegal cause, the contractor is entitled to receive a restitution up to the amount in which the state has benefit. And that is more fair. We're talking about fairness. That is more fair. The contractor is not allowing Colombian law to receive profits, but is allowed to receive the amount up to the benefit that the state receives. Or the doctrine is going to be applied in order to create an unfair situation, which is that the state will enrich. And what is going to happen to the good faith third parties that are behind the contractors? The contractor will use that money to pay the finance institutions, to pay the suppliers, to pay workers, to pay actually taxes. So this doctrine is being treated as a way really to authorize a state that has acted also with unclean hands to take advantage of their own conduct. So that Latin sentence does not apply to the state. Additionally, that Latin sentence is from the Roman law more than 2,000 years ago. I don't know if there were in Roma APPs or PPPs in English. Where in Roma concessionaires are they asking you to apply a 2,000 years old principle without taking into consideration the current facts? You have to analyze the facts. And actually, that is what is being said by the cases that were quoted by our respected colleagues. For example, in the Phoenix versus Czech case, 2009, arbitrators Brigitte Stearns, Juan Fernandez, Armesto, and Andrés Butcher, excuse me for my pronunciation, they said in the paragraph 104, so this access can be denied through a decision on the merits. However, if it is manifest that the investment has been performed in violation of the law, it is in line with judicial economy not to assert jurisdiction. So it's a very high standard. It has to be manifest. And it's good to question manifest according to whom. Is this tribunal, assuming the competence of the local courts to say that there was corruption, or you should wait for a res judicata decision of the criminal courts of the host state to say that there was corruption? In what level? When? By whom? Was it a policy of the company, or was a misbehavior of a low-level officer?
There's little time left.
Yeah, excuse me. In the LITOP cases, 2021, quoted by our colleagues, the paragraph 442, the tribunal says, this will allow and may in fact mandate that a tribunal decline jurisdiction or dismiss the claim of an investor. So I just wanted to make a complete quotation of the case, not only referring to the dismiss of jurisdiction. So in conclusion, before letting Harry to say some, in order to consider that the unclean hands doctrine, which is not clear, applies, you will need to set a very, very high standard that is not present in this case.
Thank you. And you mentioned contracts. My life would be much easier if we were facing a situation, a contract-based case in this particular situation, which we are not. So is it your position that in a case like this one, in which we do not have a contract, still I need to apply kind of similar concepts that we need to get into the merits so that we can actually talk about certain compensation to the investor? Otherwise, it would be a situation of unjust enrichment or something like that. Is that what you're saying?
Would you like to answer that?
Yeah, but it needs to be a quick decision.
Okay, it's a concurrent cause. So you need to analyze, you need to evaluate the evidence to see what is the relevance of each party conduct in order to state that it's only based on one side or half a half or 80-20. It depends. You need to review what is the relevance, the consequence that conduct had on the particular investment and the claim.
You may proceed.
I'll make two very short points.
Very, very short.
Okay. First of all, further contribution to the notion that this issue should be for the merits. The UCOS case, where the claimants argued that unclean hands doctrine would not confer upon the states the right to violate investors' rights, and argued that the principles of proportionality required the tribunal to consider investors' illegality vis-a-vis the host state's original breach. That's exactly what the tribunal did. It attributed 25% of fault to the claimant. The same with the Copper Mesa versus Ecuador case, where the tribunal said they preferred to take into account claimant's case not from the form of doctrine of unclean hands as such, but rather under the analogous doctrines of causation and contributory fault, applying to the merits of the claimant's claims arising from events subsequent to the acquisition of the investment. That result, based on respondents' case on the merits, strikes the tribunal as more legally appropriate to this case than outright dismissal of the claimant's claims on the grounds of admissibility. In the Bank Melli case that Dr. Larea signed or referenced, also mentioned that this does not mean the tribunal must ignore the evidence of future banks' unlawful activities. Rather, it must assess the consequences of these illegalities as an issue of the merits. In particular, tribunal must determine whether Bahrain's regulatory measures were a bona fide and proportionate response to future banks' unlawful conduct, and or whether the evidence of future banks' unlawful activities affects the quantification of any compensation due to the claimant. So I just wanted to point that out, that this is what the Bank Melli case ultimately held.
Thank you, Mr. Burnett. And we have a few minutes left in case you have questions. The audience has questions on. Obviously, there are probably going to be several questions about this topic because it's really interesting and broad. But if you have any specific questions that you want to ask the debaters.
On the app. So stop on the app.
Okay, I think that they're here, right? Can you help me?
And
Thank you. I'm sorry.
over down. No, listen.
Oh,
Don't make to go.
okay. Okay, let's start with this one, which is actually a follow-up to what the side actually mentioned just now. And the question is, if we admit the unclean hands doctrine as an absolute defense, what should be the threshold? You mentioned manifest, and so this probably needs to go to you first.
Sure. Thank you, Madam Arbitrator. I guess just for clarification of the threshold, we're talking about the standard or the burdens.
Yeah.
I think we can agree with our colleagues that a simple, it's hard to characterize simple unless you're looking at specific facts, but some minor violation, let's call it, of local law, is not something that we would argue or believe should warrant an absolute dismissal of a case, whether it be on jurisdiction or admissibility. But violations such as corruption, if there is, I'll say, clear and convincing evidence of corruption in the procurement of the investment, that should be the threshold that should be met, and that should result in a dismissal on jurisdiction. And I'll take an advantage here just to mention one quick comment in response to some of the points that my colleagues made earlier about whether this should go to the merits. Our position is that if the illegality is in the procurement of the investment, then it should go to jurisdiction. And if it occurs over the life of the investment post-procurement, that is a question of admissibility. And several tribunals have held that.
Any comments from you? No? Okay. There are several questions here that go to the same point, which is in cases of corruption, if, as we mentioned before, corruption is bad for society, then why not actually having the state be part of a discussion on the merits so as to deter this conduct from public office officials, which is what we said before?
As you can see, I'm pretty excited about this one. I think, so for that particular point, Madam Arbitrator, again, this goes to misunderstanding the behavior of bad actors. The only way to ensure that there is a deterrent is to recognize the unclean hand doctrine. And why? Because, again, this presumes, if we do not accept the unclean hand doctrine, this presumes that the rogue actors care about the result of the state. Rogue actors, the very nature of what they're doing is against the state, and they know that. So by making it so that that is not a defense, that makes no difference in deterrence. What does make a difference is if investors realize their claims will go nowhere. So how does that have a long-term effect on the rogue actors on the state side? Is that investors will not be willing to commit, they'll be less willing, we'll call it less willing, but they'll be less willing to commit these illegalities if they know that their entire investment is at risk. And therefore, there will be less people on the state side that will be soliciting because there are going to be less investors that are willing to even offer it in the first place or to accept it in the first place. The other way around, again, I think that is a poor judgment on what corrupt officials are thinking about. They are not thinking about the state.
Thank you. Well, I'm not sure if at the beginning of an investment, the employees of the company are actually thinking that because they are going to lose the protection on potentially on a treaty case, then they are not going to incur in that conduct. But just one point, debatable, as all we have been saying here. And then this is the last question, probably because we don't have more time, but I think this one is interesting. There's someone asking here, shouldn't the unclean hands doctrine require as a condition to invoke, for the state to invoke it as a complete defense, that the state actually takes action, prosecute, for example, the alleged perpetrators from the state side? Most questions go for you guys.
Happy to answer. Yes, we agree that should happen. It should be a requirement to prosecute.
Yeah, that one was easy answer. Okay, I think that we have come to the end of our panel and our time, and thank you to the debaters for an excellent presentation, and thank you all.
But we do scale around that.